So warm welcome to one and all. Today we are going to celebrate World Intellectual on behalf of Institutions Innovation Council. I would like to invite Dr. Merlin NJ to welcome the resource person and other dignitary. Good morning, everyone. Vice Principal Madan Sir, who is also the Vice President of the Institutional Innovation Cell, and HOD Chemistry Surya Madam, and Anusha Ma'am, and dear students, I welcome you all to this program. And you all know, as a part of institutional innovation, and today is World Intellectual Property Day. And on this day, we celebrate the intellectual property, innovation, and also economic growth. And it encourages the, if you are not about it, the right thing, we want to be celebrating this innovation, intellectual property right day. And for this, we have the chief guest advocate. And Advocate Parvati has been associated with Putran and Associates Intellectual Property Attorney since June 2006 and heads the Bangalore and Kerala outreach. Specialized in trademarks, patents, class, Parvati's day-to-day activities in the form worldwide intellectual property portfolio. She regularly advises clients on trade intellectual property due diligence involving intellectual property rights and domain name issues. She is also an experienced attorney in drafting and intellectual property licensing. And about the Putran and Associate firm, working, it is one of the leading intellectual property law firm in India with operation. And she has been working with and filing patents for various research institutions, including Indian and foreign research institutions. Multinational companies in India and across the world in various sectors of the industry, including Fortune 500 companies. The firm is actively involved in experience and creating mass awareness, seminars and classroom sessions in academic and research institutions. Engineers, researchers, and public in general about the value of IPR and its protection as well as benefit 8% for this today's Intellectual Property Day celebration. So let's all welcome her with a clap. Once again, I welcome all the students, mainly the final year students of Farm D, B Farm, and D Farm who are here to hear the thing what she is delivering. And also M.Com students. Welcome you all. Thank you. Thank you, ma'am. Next, I would like to invite Dr. Madan S., Vice Principal, Division College Computer Center for
because of this precious people who start here. Our chief guest, Pauli Madam, Bhavani Madam and your friend, then our HOD, Director of Business Studies Narlin Madam, our Head of Department of Chemistry Surya Madam, my dear students, intellectual property. Actually, first you should know what's the need to go for these intellectual properties. Then about the, especially Madam is going to give a broad idea about the patents. If you take the intellectual property of a company, I hope there are four things are involved, like patent, that's the first thing, followed by that trademark, copyrights, trade secrets. These are the four things generally a company used to have as a important thing. That's the asset of a company. So what's the relationship between the intellectual property and yourself is previous days, some 5 years before or 10 years before, whenever you are doing your PG studies like MPharm or when you are going for PhD, generally you are supposed to publish a paper in any reputed journal. Previously, an Indian journal is more than enough. After that, they have changed it to an international journal, then Scope or Index journal, and presently, majority of the university, they are insisting the students to go for patents. Presently, our central government is supporting in a lot of manner, like introducing new schemes, and with that, they what they used to say is dream and work for it. The actual thing is, suppose if you are having a very good plan, and if you discuss about that with your HOD, either our Malik teacher, Surya Madam, or myself, we will take you to the principal sir, and with the fund you can do that project, and even you can get the pattern on your name. So presently, pattern is the most important thing. Your idea that if you pattern, then you can make more money, and more money in the sense, presently all the new inventions that is based on the upware, that is to protect the environment, that is you should see the whole mass, that is the society. A simple example I want to say is the number one billionaire in the world, Mr. Elon Musk. Actually, he developed a lot of things, of which he developed on electrical car Tesla. With he registered the patent, and presently he is the number one billionaire in the world because of his innovations, that is, innovative ideas. First he dreamed, then he created a particular, he worked for that. And with the fund he raised from the US government, he made all his dreams as a reality one. Like that, each one of you should dream and work for it. Presently, a lot of fund is available, which I already told you. With that fund, you can make your dreams to come true. And suppose if you are having a dream, how you can make it as a reality, that our respected guest is going to teach you. What is a pattern, what are the types of pattern. She is a specialist in corporate law, and all the introductions are already told by our madam. So make use of her, listen to her carefully. At the end of the session, what are the doubts you are having? Just ask her. And we, pharmacists, are having a lot of chance for these type of patterns. Simple, that is, I won't take more time. Example, suppose if you find persons using a particular drug, and if it causes some type of headache or something, just removing the unwanted molecule, maybe some hydroxide or some oxygen or some molecule, if you remove it, you will get a new molecule. That molecule, if you register, the persons can use it without the headache. So that if you register, that is, if you go for the, automatically pharma companies will approach you. That's the simplest thing. Like that, we are having a lot of chances for these type of patent related things. Try to understand it and try to get the idea. Use our Bharati Madam to the full. That's what I feel. Make use of the session. Thank you.
Next, we'll move on to the session. I would like to invite Advocate Parvati Prasad to hand over the session.
morning, everyone. By the time we'll get introduce. So, thank you very much for inviting me to this particular event as Rights Day, and I'm very privileged to be able to, address your college, the students and faculty of this college on World IP Day itself. Um, and I just wanted to tell you that the theme of this year's World Intellectual Property Day is Women in IP. Okay, now I'm very glad to see so many women here, more than, and I suppose this is the apt way people are discussing about the contributions of women, property, innovation, and all of that. So, in fact, we were discussing, in our office also. Our office, for that matter, is an all-women, law firm. All of us, lawyers, paralegals, all are women. So, thank you so much once again for inviting me. So, it's always good to see that efforts are being taken by universities and colleges to create awareness on intellectual property rights. Because most of the time, what we see is that people, there's a lot of innovation happening in colleges and universities. But what happens is that people publish their inventions and thereby losing their chance to patent or protect their innovation by as intellectual property rights. So it's very critical that you know what exactly, what are the rights that you have, as inventors or creators of something, what are the rights that you have, how do you protect it, and what are the do's and don'ts, what should you do and what are the things that you should not do when it comes to protection of intellectual property rights. Now, when we speak about intellectual property rights, one word that we normally and usually use, innovation. I'm sure all of you must have heard the word, right? Innovation. So what exactly is innovation? Can anyone tell me what is an innovation? Let's make it interactive because I don't want standing here speaking all the time. Has anyone heard of the term innovation? Yes? What comes to your mind? Any idea what innovation is? Okay. No, it's not. You can tell me what is an innovation? Creativity. Yeah, I hear the word creativity. That everyone knows. Do you know who these are? Huh? Okay, on top is actually Thomas Alva Edison, but that is Thomas Alva Edison. And on the right hand side is his innovation. What was his innovation? The electric bulb or the electric lamp. And that is his patent application for his innovation. And who you see down, that is the Wright brothers. The Wright brothers and their innovation. What is their innovation? The aeroplane, right? So these are their patent applications. They are innovators, they are also patent applicants. This is another very famous innovator. That's Walt Disney. And what is his innovation? The patented invention. Did anyone know that Michael Jackson himself was an inventor? No? Got a patent for a lock mechanism. Have you seen him perform? What does he do? He stand on the stage and then he will do a tilt act. How does he do the tilt act? That anti-gravity defying act, how does he the lock mechanism on his shoe? That is, that locks himself his shoes onto the stage and then he can tilt without falling, right? So that's a tilt mechanism patent for that invention. So these are all very, very famous inventions and their inventions that you see on the. Does it take to be an inventor or an innovator? What do you need? If you look at any invention, it is always an improvement of something that is already there. So first of all, to have an innovation, right? There has to be something, some existing knowledge. You have to take something that is already there and make it or transform it into something else that is new. That is when it becomes an innovation. And then if that's something new that you create, something that is, that can create value, that's when it has value and it property right. So basically, if you're doing any of this, so, being an innovator is that you need to think out of the box. You can't be, sitting in your class learning and then, dreaming about being an innovator of your box. Like Sir said, yes, there is a lot of meaning to the word dream. If you have to dream, you have to think outside the box, right? That's when you become an innovator. Now, what inventions are entitled to intellectual property protection? Your invention need not be something very very simple invention, but it was a patent. Whether your invention is big or small, it has to be something very different, and it was not something that was thought of. If it is inventive enough, then it qualifies to be considered an invention. It may not necessarily be something very example that your vice principal said here, right? There is something already a drug or molecule, you add something to it or you remove something. It can also be an improvement of what is already there. Even then it becomes a steps to innovation. What are the three steps? The first step is ideate. I'll explain each of these steps. Third step is validate. So when you complete all three steps, that's when your innovation becomes something that is valuable. So what is ideate? What is ideate? Now ideate means you think, you dream, you start from an idea. You need to have a develop into an innovation. So the first step to innovating or inventing is idea. You need to have it. You pause around the idea. You discuss the idea within your. You discuss the idea with your research group or your peer group. You like a product or something like a prototype or something that. So the idea is translated into a product or a process. So that is the second step in innovation. What is the third step in innovation? So you test the idea, right? So the idea is becomes the product, then you experiment on that. when it becomes a intellectual property right or an innovation. So an idea which is experimented and then finally becoming a product or a. My question to you is, you all have an idea. That you should have an idea in your mind. Now let's come to our topic, which is intellectual property rights. So intellectual property rights is basically, so this is what we'll be discussing today. We'll discuss what intellectual property rights is. We'll focus, there are different types of intellectual property. So there are trademarks, copyrights, and all of that. So there are different intellectual property rights. We'll discuss that. Quickly run through the different aspects of what exactly is patents, how do you do a patent search, your patents. So we focus our attention on how and what is the patent filing procedure. You file and get a grant for a patent. So all these are the things. And why do you need patents? So what is the importance of having a patent granted for your innovation? So these are now, now let's discuss what exactly is IP. Have you heard the name IP, intellectual property right? What comes to your mind? Intellectual property. Your mind, right? The intellectual property is generated out of your mind. നമ്മളുടെ ബുദ്ധിയിൽ നിന്ന് ഉണ്ടാകുന്ന ഒരു പ്രോഡക്റ്റ് ആണ് IP എന്ന് പറയുന്നത്. IP എന്ന് പറയുന്നത് is an intangible asset that comes out of your mind, which is your intellect. It's called intellectual property, right? There is another type of property. What is it? Real estate, real property or tangible property. Like for example, your house, your land, all these are real property or tangible property. Intellectual property right is an intangible. Right? Now, what is the difference between the two? The only difference is that one is created out of a difference. But what do you do if you have a piece of land? What house? What do you do? Pass it, right? You will maintain. If it's a piece of land, probably plant some trees, or you may build a house. You may lease that house to somebody else for what? To generate money, to generate income for you. Also, if you have an IP with you, that IP has to be maintained. You have to protect it so that nobody else trespasses into it, and then you can generate value out of it or licensing it to somebody else. So just like how you maintain and how you protect your real property or your real estate, intellectual property right can also have protected so that it can generate value for it. Otherwise, it is just a piece of paper, doesn't generate any value to you. So, but if you properly protect, maintain, and then it becomes an asset or a value. Property rights. There are different categories of intellectual property. Now, I'm sure all of you must have heard of these. The first category: industrial designs, patents, copyrights. We'll focus on patents, but we'll quickly run through what the other IP rights are so that you have a broad idea on, let's say, right? So we'll also run through specific, focus on patents. Have you seen all these logos? Now, where are these trademarks used? They are always used on some product or a service. Right? Toyota is the name of a car. So you see Toyota on a car, right? That swoosh design, that's called the swoosh design. People on the left, that's called the swoosh design. Where do you see it? Nike shoe. That is also a trademark. Pepsi, that particular color combination of red and blue. Where do you see it? You see it on bottle of Pepsi. This chocolate, have you seen this chocolate? It's a Hershey's chocolate. Do you know the shape of the chocolate is a trademark? That's a registered trademark. the design on chocolate like Kit Kat is also a trademark. When you say SBI or let's say Amazon, these are all trademarks that are used on services. Amazon is e-commerce services. So Amazon would be a service mark that is used on a service. SBI on banking services. So all these are also trademarks. So what is the purpose of a trademark? It identifies the product for you, right? So when you see this Nestle, you immediately know that it comes from Nestle. You see the tick design on words, logos, or some companies use on their product that their product can be differentiated from trademarks are these symbols, names, etc. that are used on products which help customers like us identify a product from one another. Let's say you're going to a supermarket. How do you want a particular brand of soap? Obviously, you go by the name, right? You go trademarks are sole indicators. That is, that indicates where the product comes. Trademarks are intellectual property rights. The next category of intellectual property right is copyright. Copyright, have you heard of the name copyright? So if you write a poem, or if you write a book, or if you draw a cartoon, you animate, you create an animation that comes under copy because it is created out of your intellect, right? So that becomes your intellectual property right. So copyright is an intellectual property right for literary works, artistic works. You write a song, you create music for a particular song. All these are results of your creativity, and these are intellectual property rights called copyright. So copyright subsists in all these categories of works: cinematographic, sound recordings, musical work, dramatic works, choreography of a dance can be subject of a copyright. A poem that you write or a book that you write, any literary work, anything that you draw, a painting, all these are copyright protected intellectual property. Right? The next category of intellectual property. Now, what is an industrial design? Industrial design that is applicable to the outwardly appearance of certain articles. Let's say, for example, the shape of that bottle there, right? So let's say if you have a product, it can be an, but you design a very unique for that particular product, then that design can be a copyright protected design. You can register it as an industrial design. For example, chair there. Chair is a very common thing, but if you design a very new chair, then that is eligible for registration as an industrial design. So design is also, for example, the shape of Coca-Cola bottle is a registered design. A lot of companies register the shape of their products as industrial designs. Now this is, I think you cannot see, this is the last category, another category of intellectual property rights, which is geographical indications. Third is on down. Have you heard of the word geographical indications? Anyone? Here? Okay, it's very surprising. നമ്മൾ എപ്പോഴും പത്രത്തിലൊക്കെ വായിക്കും geographical indications. Geographical indications are actually certain products that have some uniqueness that is genuine. Can you give one example of the geographical indication from Kerala? നമ്മുടെ നാട്ടിലുള്ള geographical indication. Huh? Geographical indication has to be a product. It has Aranmula Kannadi. You heard of Aranmula Kannadi? Aranmula Kannadi is a geographical indication. So I cannot make a Kannadi and call it Aranmula Kannadi. Only the skilled workers in Aranmula who actually call it Aranmula Kannadi. So the name can be used only by because that the uniqueness of the product lies in the geography or the place from where it comes or the set of people, a particular group of people is an example. Pashmina shawl, Kashmir Pashmina. That is also an example. Pashmina shawl that is actually made from the wool of further garment, the Pashmina shawl is made. And because of the high altitude in which the Pashmina has a very soft texture. So I cannot make a shawl here or a piece of cloth here and call it Pashmina. Pashmina, the name Pashmina can be used, stores or shawls that are made. The producers of shawls from that area can call it a Pashmina. Scotch whiskey, for example. Can any whiskey be called a Scotch whiskey? No. And prepared in a certain way can be called a Scotch whiskey. Cognac, Cognac is also an example of a, it is a specific type of wine, sparkling wine that cognac. All these are examples of the one on the right hand side, that is Tanjavur dolls in the world. That is also specific to Tanjavur. It is actually the skill of the people that actually make that particular doll. That make a sari and call it Kanjipuram sari. Something can be called a Kanjipuram sari only if it is Kanjipuram. So these are all also that applies to certain products that originate certain territory, and the characteristic of that some is attributable to that particular geography. Now let's next intellectual property right, that is patents. So what exactly is patent? Now, then you say patents. Innovation, right? Right. So we discussed what trademarks are. Trademarks are, IP that applies to some of the names of products. Copyright is the IP that applies to, different artistic and musical works. Geographical indications are another type of IP that applies to, articles that have a particular geographical origin. Industrial design are outwardly appearance or shape of a particular product. What is patent? Patent is an intellectual property right that relates to invention. Develop, you make. That is when it becomes an innovation. And the IP right that is called patents. Now, what exactly is a patent right? A patent is basically an exclusive right that the government gives to you for a certain period of time. What is this exclusive right? It says that only you can make, only you can use that product, provided it is granted to you. So if you get a patent for an invention, that means you get the absolute exclusive only I can make it. So if I am the owner of a patent, then the government technically gives me an exclusive sell that invention, etc. So it becomes my own property, nobody else can use it, make it, do anything with that product, right? So it is an granted by the government. How long is this exclusive right? Is it an forever? No. This exclusive right is for a limited period of time. Now, and these rights, patent rights are in a certain location. Like for example, if I have a patent in India, my patent, I have only a patent protection in India, then my protection is limited or my exclusive. I cannot claim a protection for my invention in US, right? So these are the characteristics of a patent protection. So these are the laws. Generally, what law govern patenting in India? It is the Indian Patents Act 70 and the patent rules of 2003. The Government of India Controller General of Patents, Designs and Trademarks. We call it Patent Office. Patent Office is the Government of India, Department of Industry and Promotion. Under the Government of India office, the head office of the patent, the Controller General of Patents, Designs and Trademarks is in Bombay. Okay. There are patent offices in Bombay. There is the patent office in Chennai, Delhi, and Kolkata. So these are the four patent offices, Government of India patent offices, where you can file and register your patent. For anyone in South India, the appropriate patent office where you have to file is the patent office in Chennai. Okay. And there are 4 patent offices depending on the jurisdiction. It's a Government of India office which actually where you can apply for a patent and get a who can apply. First of all, the inventor himself. Yes, because the inventor is the person who invented something. Also, write in an invention. So obviously, he can apply for an invention. Now, what if the inventor was working made the invention? Then the universities or the colleges, facility that is used to invent. So in that case, the university can also, then the inventor will have to give all the rights to the university and make an application. If the inventor or the is dead, then his legal representatives can also file an application for a patent. Now, the very important question: are all inventions patentable? All inventions are patent but not all inventions are entitled to a patent. So if you invent something, you have an invention. For it to qualify as a patent, there are 3 important criteria. Right? Only if you satisfy these 3 criteria will you be entitled to apply for a should not be used, it should not be a world evidently if somebody has disclosed, then you are not eligible for a patent. Patentability or newness is the absolute criteria for patentability of an invention. So, and for the same reason, it is always a question for you file a patent for it because see, if you publish your invention, it is already there is no novelty to your invention. So if you yourself publish your invention also, you are not eligible for patent because patent has to be for an absolutely new unpublished invention. So if you have an invention, if you have a product or a process that you think is eligible for invention, because if you publish the invention in any scientific journal, it will be it will violate the novelty feature of the invention because newness or novelty is the absolute criteria for patentability. And the next criteria is inventive step or non-obviousness. What is inventive step? Now, I said earlier, all inventions. See, you can't every invention that you see will obviously started from the wooden wheel, right? So every invention and every step of development is always an improvement something that is already there. So are all improvements entitled to patent? Will not make it patentable. It has to be something inventive enough. Another word for inventiveness is non the drug and a new particular molecule or a certain function of a molecule. I could have also made something that I have also thought of. Angana Tonumpo invention is not a patent. That a person skilled in that particular field should not have thought of. That's non-obviousness. Obvious means very obvious. Very obvious invention. Obviousness is simpler. So, an obvious invention. So, obviousness is also a very non-important criteria for assessing patentability. This is a very subjective criteria, very difficult to establish. The patent office raises an objection that your invention is obvious. Obviousness is also another criteria for patentability. The third criteria is industrial applicability or utility. Your invention should have some patent. There has to be some industrial applicability to the invention. And right, see, when you file a patent application, take your product to the patent office and show it to them and say, see, this will work like this. That is not possible. You cannot show the patent office the prototype of your invention. So you actually write down your patent. We call it a patent specification. So when the examiner at the patent office reads your product has a certain therapeutic effect, a drug has a certain therapeutic effect, but this will not workable. It will have to be proved that it will work. So in the workability is also very important criteria for patentability. So invention should be new, invention should be inventive or not obvious to a person skilled in the art, and finally your invention should work or should have some use or some applicability in industry. Now apart from these three criteria itself lays down a certain invention that are referred falls under any of these criteria also, it does not a patentable. First of all, anything that affects the health or morality or anything that affects the environment. For example, if that obviously is not a patentable. So it is something that is hazardous to the invention should not be contrary to natural laws or anything that to the health of human life. Now this invention. Now, if you discover something that is already there in nature, that is not patent. Like it is not an invention. So invention has to be differentiated from discovery. So something that is naturally occurring. Not an invention. So discovery of a living thing or a non-living thing that is naturally occurring not be a patentable invention. New form of a known substance. And I am just probably, my new invention is let's say, for example, the salt of that particular molecule or that particular compound. That is not a patentable invention. It is only a new form of a known substance. It's also not a patentable. For example, all of us know that turmeric has a what do you call antibacterial property, right? Now my finding is that turmeric also has anti-cancer properties. That is not a patentable invention because turmeric is already known to everyone. Turmeric's property used as patentable invention. For something to become patentable, it has to have an additional effect, and only then it becomes the new patentable invention. You are simply mixing two things. Let's say, for example, A has a certain property, certain effect. Compound B also has a known property. I am mixing of this and this. That is not a patentable invention. So mere admixture or mixing of two compounds with known properties, patentable invention. When does it become patentable? To add something else to it and then it has a patentable invention. Or a diagnostic method is also not patentable invention. Plants and animals cannot be patented. Agriculture, horticulture methods cannot be patented. Anything that is part of traditional knowledge, like I said, a property of neem or the antibacterial property or antifungal property of turmeric. All these are part of traditional knowledge. And therefore, already all these are not patentable inventions. So anything that is part of traditional knowledge, as in Ayurveda, Unani, or all those texts are also not entitled to a patent. So if your finding relates to any of these, and which has scope for patenting, there are certain things that you should not do for to make yourself eligible for a patent or to have some scope for patent protection. First of all, the first important thing is that you have to maintain your research. When you do a research, all the data that you have, they become very valuable information for people like us, patent lawyers, to draft the patent specification. So always maintain records of your research work because they are very valuable application. So maintain records of your research work. Secondly, do not publish. That is something that I said before also. Do not publish your patent application. Do not publish your invention, because if you publish your invention, what happens? You lose the novelty criteria. You do not comply with the novelty criteria of your invention. So you should apply for your patent first, then publish your invention. Thirdly, yes, if you can work your invention in your lab, you can trial out, you can do clinical studies, that trials and everything. All those can be done, but publication is what is prohibited when it comes to patents. Always conduct a patent search. See, we might think that your invention, our invention, not necessarily. It may be something that is already or somewhere in US, some researcher must have filed a patent for something. So it is always advisable to do a search to find out whether your invention is actually new, whether somebody else has already invented it, somebody else has published it somewhere. After doing a search only, you assess the newness of your invention and then file a patent. So search, patent search, we call it prior art search. I will come into prior art search in the later slides. This search is very important in patent. What is a search done for? Search is done to assess patent, filing procedure can be very expensive or time. So first we identify whether your invention is satisfying the novelty criteria. The search is also a very important step when it comes to a patent filing procedure. Now in patents, I don't know whether you noticed in one of the first slides, I said patent is a statutory right. Statutory right is one and another. Statutory right, that means your patent is a patent only if it is. When does it become a patent? You apply for a patent and you grant it. So patent protection, so for the same reason, the filing date of your patent is very important. It is always advisable to file your patent as early as. Do not wait for your entire invention, your entire research to be complete to file a patent application. Because if you wait for 2 or 3 years, the chances of somebody else filing something similar in some other country are very, very, very high. And you will lose your chance to patent it because it is always the first to file that has priority. So if you file it today, anything that is filed after your application is your novelty, but any invention challenge to the novelty of your invention. So which is why we always advise clients to file a patent as early as possible. There is a scope for patenting that invention, file your application as early as possible. How do you do that? We will explain in the next It is always advisable to select a patent attorney and then draft the specification because it is a very document, but there's also a lot of legality in a patent specification that is being drafted. So it is always advisable to choose a patent attorney and then use that patent. Finally, even after grant, you have to keep your ensure that there is maximum commercial exploitation. A patent is just a piece of paper. It is certificate or invention, you have exclusive rights. See that becomes that remains a piece, just a piece of paper. something that we discussed in the first slide, right? It has to, your IP has to generate some. Similarly, if you have an invention that is patented, for which you have exclusive rights, you do some, you can license it to, a potential buyer and then get royalties. Right? That is where it generates value. So commercialization of patented inventions is also very important because only then will your invention realize value for you. Like I said earlier, search is something that is a very important thing done by inventors and researchers before they file a patent. Search is called prior art search. What is a prior art search? The prior എന്ന് പറഞ്ഞാൽ എന്താ? Before. നേരത്തെ ഉള്ള. Art means knowledge. So prior art search for already existing knowledge. ഞാൻ പേറ്റന്റ് ഫയൽ ചെയ്യുന്നതിന് തൊട്ട് മുന്നേ വരെ what is the existing knowledge? അതിൽ നിന്ന് സെർച്ച് ചെയ്യുന്നതിനാണ് patent prior art search എന്ന് പറയുന്നത്. What is the need for doing a patent? To assess the newness of your invention. Novelty criteria. So to assess the novelty criteria of your invention, you do a patent prior art search. And where do you search? You search in the existing database of knowledge, right? So where do you search as patent attorneys? We search in scientific journals, we search other patents, we search in publications, books, etc. to find out what is already there and whether if my invention is something that is already search in scientific journals, you search in patents filed in India and other, find out whether there is any disclosure. We always do prior art search whenever somebody comes to us for filing a patent application. The first thing is the patentable ആണ്. എങ്ങനെ check ചെയ്യും? Which will affect the result. Checking the patent an invention, we do a patent prior art. Now, it helps you assess the closest. It contains the latest research in the they contain the latest development done in that particular field. So identifying the closest prior is also one reason why a lot of universities do patent prior art searches other than checking patentability. And thirdly, it helps you file a strong application. Let's say, for example, when you do a patent prior art search, you identify that there is something very close. What does it help you do? It helps you modify your research, right? So you know this is already there. Make your patent invention patentable. Registration as a patent. This is a very important point. Check for infringement. So patents, right? So that company will have exclusive right over that. I'm going to launch a new drug into the market. What if that drug is already patented? What will that guy do? He will file a patent. So it is very critical for me, pharmaceutical company or any company for that matter, before launching a product into the market, to know patent infringement suits can be very expensive. Probably claim crores of rupees as damage for a patent infringement. So it is very critical. They are launching a new product into the market. They need to identify whether I am infringing somebody else's product, right? Somebody else's patent. So to check infringements is also companies do patent prior art searches. Whether what I have invented, what I am going to launch into the market is already covered by somebody else. And check for infringements also, we file for patents. And finally, I am Apple, you know, the mobile operator, the mobile company Apple. I'm doing a lot of, I will always want to know what Samsung is doing because competitor. So as a company that is specialized or focused in a I'm also filing patents. So what is the research that I'm doing? Where do you search? I just need to search the patents that they have filed. So patent searches are also done by companies to know the so if you look at the patent documents or that research organization. So a lot of companies do patent prior art search that is happening in the competitors business also. Now, this is a very funny incident that happened long time back, which actually explains the importance of prior art search. So, like I said, what is the reason we do a prior art search? What happened was in 1964, there was a Danish inventor. He found out a very fantastic invention. What was it? He said, if a ship is or a boat is sunken, under a lake or a sea, how do you lift that ship up? From the top of the water from another ship, you filling buoyant objects, balls in it, air-filled balls, you can fill into the ship down here. Obviously, when you fill the ship, the weight will decrease. So the invention was that how to lift a sunken ship from the bottom of a ship and lift it up. This was Carl Troyer found, he did a search, nothing was available. He thought his invention was very new. He applied for the patent. The Danish patent office rejected his patent. Saying, what was the reason? There was a 1949 Donald Duck magazine ping pong balls into a ship that was considered as a prior art for rejecting the newness criteria of the importance of doing a prior art search and can be a potential threat to the newness of your invention. Where do you search for prior art search is something that to a large extent you also can do. I would also urge you to start using all these websites, not just in terms of filing a patents, but also to obtain. Let's say, for example, if you're doing research in the field of pharmacology, it's publicly available sites. You can actually do, just like how you search which colleges are filing and what are these in these websites. These are some free or open source databases. One is Google Patents. Google Patents is some just Google Patents and Google keywords everything. Your invention like keywords everything. Can pull out inventions in that particular field. So Google Patents is a free database. Lens is also a free database. Free is also a free patent database. It will contain databases of different countries, not just in patents. The second is patent databases from one, the patent office database. So countries like USPTO, INPAS is the Indian Patent Office database. Patent Scope is a World Intellectual Property Rights patent database. ESpaceNet is a European Patent Office's data. These are also great patent databases. You just need to, Google for this, go search for patents. So these are all free patent databases. The last is paid databases, which is normally used by patent attorneys like us. to do focused searches for clients. So, paid databases, Package, First Login, RCL, etc. So if you can note down these three databases, please note them down and try what sort of research is happening in different fields. Now let's see how so you have, let's say you have done a search, so you have an invention, you had an idea, you can start with idea. You had an idea in mind, you experimented on that idea, you built something on it, you did a your patent attorney gives you a go ahead. Yes, this is you have done a search, there are no similar inventions, this is a patentable invention. What do you do next? So the next step is to file a patent application for your invention. So there are two ways in which you can file a patent application. If you recall, I said earlier that it is always advisable to file a patent application as early as possible. You don't need to wait if you're doing CLO, right? So you don't need to actually what your product is going to be. At that stage also you can file a patent or a provisional application. Why do you file a provisional application? To put your application as early as possible. The chances of you losing the novelty file a by the time you complete your research and you have your product ready, 2-3 patents would have been already filed by somebody else from some other university in some other country, right? And your novelty is across the world. Product should be new across the world. What will happen when you file the application? The university in China has already filed a patent, your patent is rejected, right? So that is the reason why we always advise clients to file patents as early as possible. You can file a provisional application. But you know that this is what your product is going to be. At that stage itself, you can file a patent application. It's called a provisional application. So when you file a provisional application, you have to disclose each application. Your patent application will be refused or rejected. So what are the things that you need to cover in the product? You cannot take the product to the patent. These are the properties. So how you draft the patent specification? Because with that specification, you should be able to patent or the person in the patent office that the invention will work in this manner, right? So these are the essential components of a patent application. To have a title, what is the title? Always in patent applications, drawings are diagrams. Finally, you give a detailed description of choice. And finally, how do you perform? How do you work your invention? How work? That also has to be explained. And then finally, the claims of the invention. What are the claims? What do you claim? See, when you draft a patent specification, you have to give the background. What you actually get a patent for. And finally, a short abstract, a short note on what exactly the invention is all about. So these are the contents of a. Now, to quickly give you what happens when you file a patent application. So, like I said earlier, if you're filing a provisional application, then you take 1 year of filing the provisional application. Now, after you file, so it's always your first file, first patent application. Now, from the date of filing the first application, for the first 18 months, your patent application publish your invention, right? In an official gazette called the Patent Office Journal. Once the publication happens, then your patent is published, right? Now, after publication, you have to file a request for examination of the patent. Now, only if you request the patent office to examine the patent by paying a fees, the patent office will take it up for examination. Now, what is examination? Examination is a process that satisfies all the three criteria for patentability. Whether it falls under any of the inventions, yes, for the first examination report or FER. The FER in a patent application will cite all the objections against your patent, why it's not entitled to patent and all that. Then you have to respond to that. And see, even though there are objections, my patent is entitled to a grant because of these reasons, then the patent will be granted to your invention. If the patent office feels that your invention is patentable, or that there are other prior inventions that your invention will be refused a patent. So this is the general process for a patent. The time period taken can be anywhere from 2 to the patent office. So approximately, when you, from the date of filing your patent application, let's say you file the complete specification, what is the nature of the patent right, the exclusive right? It is a 20 years. And this 20 years starts from your date of filing the application. So from the date of filing your application for 20 years, you are granted a patent. Now the very important question, why do you need to file patents? The patent filing. Why do you need to file patents? Why patent filing is encouraged? Patent file ചെയ്യാതിരുന്നാൽ anybody, if I don't protect it, anybody can use it, right? So the first reason for patenting is the exclusive rights that are granted to me for filing that, for getting that patent. So it's because that gives me a very strong market position. Let's say, for example, product that is patented and I am marketing that product. What is my advantage? I get a very strong. Okay. So companies patent for the strong, for the exclusive rights that they get for the product. They have an exclusive right to use that particular product. So exclusive rights, strong market position that you get because of the patent rights are reasons why people, why patents are recommended or usually for companies. Now, another reason is that, see, in patent, you cannot do research, you need a lot of facilities, you need a lot of raw material, right? So went into your research. The product. But you don't have the opportunity or facility, right? You don't have the facility, you don't have, so what do? You can still make money on it. Discover, I'm sorry, that you invent, then obviously company, right? If the company is ready to buy your patented product, then you can sell it to them, and then get money for the sale, or you can license it to them. What is license means? You're only giving them the rights to, right? So you can license it also. So even if you do not have the capacity or the facilities to manufacture and licensing it to a potential colleges, it is a very positive image to say that, you know, in my name. That is a very, very positive. That has a certain number of patents, that is always considered as the expert. What is the kind of advancement that the company, advanced research that the company is doing, and that is very positive thing for a university. So definitely having a patent portfolio to say that you have the patents creates a very positive image. And then that person can prevent you from. See, നമ്മൾ എന്തിനാ പേറ്റൻസ് ഫയൽ ചെയ്യുന്നത്? Obviously patents എന്ന് പറയുന്നത് exclusive rights ആണ്, അല്ലെങ്കിൽ that it actually adds to the collective 55 million patent documents in them, and they contain the latest scientific advancement. Want to know the latest scientific advancement? Everybody search it. Just search their patents. Our company, but the patents are also patents are a very a large body of knowledge that is out there, that is available for the public to see. And what is the reason for patenting? I get an exclusivity over that particular. As a patentee, I am required to disclose my invention. From that, right? So why otherwise, if I don't patent it, because people will continuously innovate. How do I further research? How do I do of having a patenting system is to make the entire body of knowledge to show you how initially it was always companies that used to file cases. But now, if you look at the trend that is happening, large number of where the universities file the largest number of cases compared to countries like US, UK file the maximum number of universities file cases. So the number of universities much higher in India when compared to lot of other countries. But what happens in my experience, what I got to the patents that is coming out of universities, there are very critical inventions. But what happens is that, like I said, it remains in patent. Right? Nothing happens after the grant. So it doesn't go to the next level. What is the next level? There has to be, the invention has to be commercial. Pharma, obviously your industry will be pharmaceutical industry. Of adding any value to the public. And I know that there are a lot of, for example, one of our research organizations is also into pharmaceutical research. Their inventions, the inventions that they make are actually licensed to a clinic, right? And they're making money out of it. So the entire that, even if you have, it doesn't matter. Partnership with the industry so that you if you have any questions, you can ask me. I know it's a very long session and I will continuously have it. So if you have any questions, any doubts, ask. Yes, it's going.
Now I invite the memento as a token of appreciation from our part. Thank you, ma'am. Now we can wind up the session. I would like to invite Dr. Surya Pia. Very good morning to one and all. My responsibility to thank the importance of patent filing sheet. Invention, right? Then only we can go ahead and search. Then we can complete the file up. And how long if we
to make it a